Good afternoon or good morning, wherever the case may be, where you are. Welcome to this panel on the Equal Rights Amendment and higher education. Almost 100 years after the first version of an Equal Rights Amendment was introduced in Congress in 1923, it is still, for reasons that pass understanding, not the law of the land. We are very fortunate today to have a panel to discuss with us why that is and talk about the future of the ERA. With us today are Jessica Neuwirth, Julie Suk, and Elizabeth Schneider. Before we begin with their talks, I'd like to tell you a little bit about each panelist. Our first speaker will be Jessica Neuwirth, an international women's rights lawyer and activist. Jessica is a distinguished lecturer and Rita E. Hauser Director of the Human Rights Program at Roosevelt House in the Public Policy Institute at Hunter College at CUNY, the City University of New York. Jessica is also one of the founders of Equality Now, an international rights organization established in 1992, and the founder and director of Donor Direct Action, an offshoot project now hosted by the Sisterhood is Global Institute to support women's rights organizations around the world. She is also founder and co-president of the new ERA Coalition, mobilizing a renewed effort to get the Equal Rights Amendment into the US Constitution. To aid in this effort, she has also written a book entitled Equal Means Equal, Why the Time for the ERA is Now. Please join me in welcoming Jessica. Hi, Jessica. Our next speaker will be Julie Suk, Dean for Master's Programs and Professor of Sociology at the CUNY Graduate Center. Julie is a scholar of comparative law and society with a focus on women in comparative constitutional law. She is most known for her recent work on renewed efforts to ratify the ERA in light of the theory and practice of gender equality provisions in constitutions around the world. Her dozens of articles and book chapters address the potential and the limits of anti-discrimination law as a tool for eradicating social inequality. Julie's new book on the ERA is entitled We the Women, the Unstoppable Mothers of the Equal Rights Amendment. Please join me in welcoming Julie. Last but certainly not least, we have Liz Schneider. Liz is the Rose L. Hoffer Professor of Law at Brooklyn Law School. Liz is a national expert in the fields of federal civil litigation, procedure, gender, law, and domestic violence. She is author of the prize-winning book, Battered Women and Feminist Lawmaking, co-author of Domestic Violence. Excuse me one second, I've dropped my glasses. Co-author of Domestic Violence and the Law, Theory and Practice, and co-editor of Women and the Law Stories, as well as many, many other publications. She teaches and writes in the fields of civil procedure, civil rights, women's rights, and domestic violence, and has been teaching on women and the law since 1974. Please join me in welcoming Liz. Some quick housekeeping matters for attendees. This session is being recorded. Attendees should use the chat function throughout the talks to post comments. I will be monitoring the chat so that I can share comments with the panelists. After the panelists have spoken, they will each speak about 20 minutes. Feel free to ask questions through the Q&A function. Our timing is as follows. As just noted, each panelist will speak for about 20 minutes, bringing us to approximately 3 p.m. Eastern Time. We'll have about 20 minutes for your Q&A, and at about 3:20, I will ask each of the speakers for any closing comments. Attendees should note that after this session is over, you'll need to return to the conference landing page for the link to get quick access to the next session you want to attend. Thank you for your attention, and let's get started. First, we'll hear from Jessica. Thank you all.
Thank you. Can you hear me? Okay, great. Great. Thank you very much for organizing this panel and for inviting me to come and speak to you about the Equal Rights Amendment. This really could not be a more exciting time to talk about the ERA with the resurgence of interest and activism, and most importantly, real progress. We are closer today to constitutional equality than we have ever been. And I think my job today is really to just set the stage with a little bit of background on the ERA. So the Equal Rights Amendment, as Karen mentioned, was written in 1923 and first introduced in Congress. It was actually passed by Congress in 1972. with a 7-year time limit that was then extended to 10 years. And initially, there was a surge of ratifications. Within 1 hour, Hawaii, the state of Hawaii, ratified the ERA, and there was just a mad rush. 22 states within the first year ratified the ERA. But then ratifications kind of ground to a halt. And although the 1979 time limit was extended by Congress to 1982, there were no further ratifications in those last 3 years, although a few states came quite close. And then in 1982, when the time limit expired, the ERA pretty much fell off the radar screen for most people and became relatively invisible. Although activists scattered around the country did try to keep it alive, and it's important to note that the ERA was reintroduced in Congress in every single session. I personally came to know of the ongoing ERA effort through Congresswoman Carolyn Maloney, with whom I had worked on anti-trafficking legislation. And about 5 years ago, I met her to update on the latest anti-trafficking efforts. And she said, look, we really need to pass the ERA. We need something permanent. We need a constitutional guarantee of equality for women. And she just felt that legislation was fine, but it could be rolled back with any election. And we needed something more permanent. And for all of the decades that she had been introducing the ERA, it really hadn't gone anywhere. There was no vote, there were no hearings. And I think what she realized and what she explained to me was that we needed to build back a broad-based public constituency for the ERA. No one was really talking about the ERA anymore, and many, if not most people under my age, didn't really even know what it was. And certainly no one in Congress was hearing from their constituents about the ERA or from anyone else other than Carolyn Maloney. So lots of members, mostly Democrats, were putting their name on the bill at her request when she would collar them in the hallways, but it wasn't really taken seriously. And it was in no way a congressional priority, for pretty much anyone other than Congresswoman Maloney. So I took all of this in and started talking about the ERA, trying it out on friends and colleagues, and many in the women's movement who had been active in the 1970s campaign for its ratification. And one of the things that I encountered in my informal polling was that many people thought we already had the ERA. And that is what our own formal polling in the ERA coalition has found too, that 80% of Americans mistakenly think we already have constitutional equality for women. And that same polling also shows that 95% of Americans think that there should be a constitutional guarantee of sex equality. So we realized that primarily our problem was an information gap, and that was the greatest challenge. Because when people find out that we don't have equal rights in the Constitution, I think often a sense of outrage follows that. And then our challenge is simply to move that outrage to effective political action. So that's what we started to do, and much has happened since then. And now, as I mentioned, I think we are literally on the brink of constitutional equality, which is very exciting. But some skeptics, after learning that we didn't have the ERA, were also asking whether we really need it. I think they were seeing there had been improvements over the years. It used to be 59 cents on the dollar for what women made for every dollar that a man made. And now I guess it's around 82 cents, although it's much less than 82 cents for women of color. There are more women certainly in Congress. That's been steadily growing than there's ever been, but it's still only about 20% more women running companies, rising in the workplace, although we all know that sexual harassment was quietly devastating them, and the work-family balance issues were making their lives impossible in many cases. So until just a few years ago, I would say there was a kind of complacency and a sense that, well, we're making progress. And also this sort of lack of information about the ERA because it didn't have much attention. But since then, really everything has changed. I think a pent-up rage exploded into the spontaneous Women's March in Washington in 2017, which spread like wildfire around the country and around the world. And then #MeToo exploded into a new surge of energy, a movement that's visible, strong, and seems to have staying power. So then many started asking in this wake, well, what can we do to ensure meaningful systemic change? And I think the ERA is a big part of the answer to that question. But as I said, people were asking, why do we need it? And that's really why I wrote the book, Equal Means Equal, Why the Time for an Equal Rights Amendment is Now, to explain why we need constitutional equality and to show that the legal framework that we have now is not enough, that it's not really working for many women who suffer gender-based injustice. And I tried to highlight in the book cases of real women who suffered real harm and were unable to get the protection that they need and deserve from the law. Many people think that we don't need the ERA or that we already have it because of the 14th Amendment. Everybody knows equal protection of the law. And that sounds good, but we have to remember that the 14th Amendment was passed in the 1860s, and it was only 50 years later, and as a result of another amendment, the 19th Amendment, ratified in 1920, that women got the right to vote, which is the right that we are celebrating this year, 100 years later. And it was right after suffrage in 1923, 97 years ago, that Alice Paul drafted the ERA to make sure that women got all rights, not just the right to vote. So clearly the 14th Amendment was not working for women if women couldn't use it even to get the simple right to vote. And it was only in the 1970s for the first time that the 14th Amendment was used to address discrimination against women. And it certainly has had, in fact, much positive impact, but not enough. And for anyone who doubts that, I often quote the late Supreme Court Justice Antonin Scalia, who said publicly, clearly the Constitution does not require discrimination against women. The only question is whether it prohibits it. It doesn't. So that's his view, or was his view. And Justice Ruth Bader Ginsburg also said a number of times that it was her first and greatest hope to see the ERA in the Constitution. So in my book, I address various areas of discrimination: pay inequity, pregnancy discrimination, gender-based violence. And I think we all think of Title VII and Title IX of the Civil Rights Act as important legal remedies, and they can be, but there are many limitations and exceptions to these remedies. They work in some cases and not in others. So with equal pay, just for an example, there's an exception in the law for factors other than sex. And this exception has been interpreted to include your salary history. So two people doing exactly the same job, one can get paid less if one of them got paid less in the last job. And guess who that would be? We all know that women get paid less than men. So how are you going to remedy this if any employer can rely on the last lower paycheck to justify the new lower paycheck? It's a vicious cycle that enables employers to pay women less so long as they keep doing it. And that's even disregarding any prior experience. We're not saying one person had more experience than the other. A woman with the same level of experience as a man can get paid less than him because she's always been paid less than him, and she has no legal recourse under federal law. And legislative efforts to correct this, such as the Paycheck Fairness Act, have been unsuccessful in Congress. And another area where the constitutional protection gap is very evident is gender-based violence, which I think is the most dramatic illustration of why we need the ERA. In 1994, the Violence Against Women Act was passed, which included a provision that enabled women subjected to gender-based violence to take their cases to federal court. And soon after the law passed, a young woman named Christy Bronchalla brought her case to court. And her case, so many years ago, could read like any sexual assault case today. She was in college first few months as a freshman. Several varsity football players raped her, one of whom admitted having sex with her without her consent. But Christy couldn't get justice, and her case, which came under this new Violence Against Women Act against her rapists as well as the school, went all the way up to the Supreme Court, where it was thrown out. And it was thrown out not because it wasn't gender-based violence, but because the court decided there was no constitutional basis for this provision of the Violence Against Women Act and struck that provision down. The 14th Amendment is limited to state action, and all of these remedies for violations in the private sector, including Title VII and Title IX, fall under the Commerce Clause of the Constitution, which historically has been stretched to cover almost everything under the sun. But in passing the Violence Against Women Act, even though Congress extensively documented the economic impact of violence against women on the national economy, the Supreme Court ruled nevertheless that this didn't fit within the Commerce Clause. So the line in the sand was drawn by the Supreme Court to exclude violence against women. Now, if there had been an ERA, another constitutional basis for this legislation, this provision of the law would not have been thrown out. So when people ask what difference the ERA would make, I wonder what would have happened if Christy Bronchalla had been allowed by the Supreme Court to bring her case, and if she had won her case, and there would have been a precedent decades ago for accountability for campus sexual assault. and presumably many more cases to follow that would have created a climate of accountability rather than the climate of impunity that we're struggling with now. And in that scenario, over the course of 30 or 40 years, it's easy to imagine that we might not today have the epidemic of campus sexual assault that we now have. So those are just a few areas and examples of why I think the ERA is needed to help us fill this gap. And the key question we've been focusing on is how do we get it? And I just want to note that most countries in the world already have constitutional equality provisions. And that in some cases, such as Iraq and Afghanistan, our own country has really strong-armed them into including a provision like that, even though we don't have it in our own constitution. And as you may know, the United States is one of the few countries in the world that never ratified CEDAW, also known as the International Bill of Rights for Women. The only other countries in the world that haven't ratified CEDAW are Iran, Sudan, South Sudan, Somalia, and little island countries of Palau and Tonga. And CEDAW, among other things, provides that states should have a sex equality provision in their constitutions. So without CEDAW and without the ERA, we are missing the legal framework for women's rights that almost all other countries have. Now, amidst all this, in 2017, State Senator Pat Spearman led a successful effort to get the state of Nevada to ratify the ERA, becoming the 36th state to do so and the first state since the 1970s. Then in 2018, Illinois voted to ratify the ERA, becoming the 37th state to ratify. And in January of this year, Virginia became the 38th state to ratify the ERA, the last of the 38 states needed for a constitutional amendment under Article 5 of the Constitution, which governs amendments. And Article 5 has two requirements. 2/3 of each House of Congress has to vote on the amendment, and then it's sent to the states where 3/4 of the states, or 38 states, have to ratify it. And upon ratification by the 38th state, according to Article 5 of the Constitution, the amendment becomes valid for all intents and purposes. So right now, the state of Virginia, joined by Illinois and Nevada, take the position that their votes have brought the amendment into the Constitution as the 28th Amendment. But the archivist, whose job it is in Congress to certify amendments, has been directed by the Department of Justice not to certify the ERA as the 28th Amendment. And the 3 states have joined together in a lawsuit to try to compel him to do so. Meanwhile, in February of this year, to remove any question about the time limit of 1982 set by Congress, the House voted to remove the time limit altogether. And a bipartisan companion bill in the Senate, co-sponsored by Senator Ben Cardin and Senator Lisa Murkowski, has not moved forward. But we've worked to make the ERA an election issue, and we believe that no one who opposes the Equal Rights Amendment has any place in Congress. Another legal issue I'll just mention in case it comes up is the status of ratifications, and in particular that 5 states had voted after their ratification to rescind their ratification votes, all of which happened in the 1970s. Now, as it happens, when the 14th Amendment was ratified, the certification of the amendment includes a list of states that had ratified, and that list includes several states that subsequently voted to rescind. So there's precedent to suggest that once a state votes to ratify, it cannot then subsequently rescind its ratification, which I think makes sense if you think about it, because otherwise, how would you know when an amendment was finally and definitively in the Constitution if it could be rescinded any time before? And the other point about Article 5 of the Constitution is that it says nothing either about rescission or about time limits. So there's a lot of legal uncertainty about these issues. And I think one way or another, they're going to be addressed by the courts or the legislature in maybe the next year. So that's where we are. And we really hope that everyone will jump in and help us kick the ERA across the finish line, which you can do by helping us lobby the Senate to remove the 1982 time limit. And the bill pending in the Senate is SJ Resolution 6. And also by helping us to just get the word out so that everyone really knows what the ERA is and that we don't still have it in our Constitution. Leaving women out of the Constitution has helped promote the message that women are second-class citizens. And it's created a culture that allows sexism in all of its forms, some deadly, to continue with impunity. Going back and fixing the Constitution goes to the root cause of the problem. So I hope that you will find out more including where various candidates for election stand on the ERA. Lots of information, including that information, is on our website at eracoalition.org. This is really a fundamental human rights issue, and I think I am probably running out of time, so I'll stop here and would be glad to answer any questions later. Thank you.
Thank you, Jessica. I'm sure there'll be some questions later. Julie, would you step in now and talk to us a bit about your new book and your own research on this topic?
Absolutely. Thank you so much for having me. And I am really going to try to keep to time because I'm actually dying to hear what Elizabeth Schneider has to say. I've been a reader and fan of your scholarship for a very long time. So I'm going to try to keep to time. And I'm just putting into the chat box now a link to my book, We the Women. If anyone wants to get a signed copy, it was just published in August, and it's really the first book that really tells the story of ERA ratification in the 3 states that Jessica mentioned. Nevada, Illinois, and Virginia. A third of the book is devoted to the legislative history of those ratifications. And the rest of the book is a history of the ERA in Congress and sex equality in the courts in the making of the ERA over the past century. And so if anyone wants a signed copy, I can't send you a signed copy, but if you buy a book and let me know by email, I am happy to send you a signed book plate. You have to send me your mailing address though, but I put my email in. You can follow me on Twitter. I often tweet about what's going on with the ERA at Julie Seesook. So that said, I actually, the remarks that I prepared were actually keyed to the ERA in higher education, which I thought was going to be the focus of this panel. But I will say one thing. I think we're at a very interesting moment in our nation's history with the composition of the Supreme Court about to shift in a very fundamental way. And the country has really been focused on that about to happen. And that will certainly raise questions about what's possible, even if the ERA is in the Constitution. Jessica mentioned all these ways in which the ERA could be a tool. If the ERA could be interpreted in a manner that applied to corporations that are underpaying women, the text of the ERA says equality of rights under the law shall not be denied or abridged by the United States or by any state. So it would take a real radical shift in the way that courts think about that kind of language to apply it to private employers. So that's one challenge. Another challenge is that a lot of the issues around Congress's power under Section 2 of the ERA, if the court were to take the same approach to Section 2 of the ERA as it does to Section 5 of the 14th Amendment, you would not see the expansion of congressional authority over things like the Violence Against Women Act. That's not to say it's not possible. Everything that Jessica is saying that the ERA could do are things the ERA could do, but won't necessarily do. It'll depend on who the judges are. And I think right now we're having an intense conversation about who our judges are and going to be for really the next generation. And so part of the reason I wrote my book, which just came out this year, is that I thought that in the face of judges who care about the framers' intent and judges who care about the public meaning of a piece of constitutional text when it's made, ought to care about the women who made the ERA. Women are founders and framers, and women have become founders and framers by participating over the last 100 years in making the ERA, introducing it in Congress, ratifying it in state legislatures. And I thought that if we could really take a deep dive into the process by which the ERA was made, we would know what the thing means. Because I think the language of the ERA is very abstract. Equality of rights can mean a lot of different things to feminists than it means to, say, the activists who are part of the men's movement. But I think one way in which we can come up with a meaning that we can hold judges accountable for is by looking to what it has meant in its legislative history, although not all judges are interested in legislative history, and in the public meaning that's created through debates in Congress, debates in the public, and debates in the states that recently ratified. And what's special about the ERA, the idiosyncratic history that Jessica just described, by which it's written in one generation, 1923, and rewritten in the 40s, then adopted in another generation, 1972, and then completed ratification in 2020, is that its meaning has changed over time. That is, in 1923, they might not have been as focused on some of the issues that we're focused on today. They might not have, I'm sure sexual harassment existed, but the idea that the law should do something about it and that women are entitled to the law doing something about it is more of a late 20th and 21st century idea. But how do we get a 21st century idea into an amendment that began so long ago and was adopted by Congress 50 years ago? And I think that part of the reason I wrote the book was to really think about how the unfinishedness and the transgenerational making is actually making an amendment that's about so many things that the women did not necessarily think about in the 70s, but are related to things they thought about. And some of the inequalities that they were focused on in the 1970s was, of course, women's lack of educational opportunity or unequal educational opportunity. And when you look at the women, there were only like 10 women in the House and 1 woman in the Senate at the time that the ERA was making its way through Congress in the early 1970s, including the first women of color who were elected to Congress, Patsy Mink, the first Asian American woman in Congress, and Shirley Chisholm, the first African American woman in Congress. And as they advocated for the ERA on the floor, they also actually were, especially Patsy Mink, the mother of Title IX, were incredibly engaged with what it would take, not only to get a constitutional amendment on equality for women, but what it would take in terms of legislation to make equality real. And Title IX was a very important part of that project. Title IX does much more than simply prohibit sex discrimination in educational opportunity. Title IX, and particularly because of the ways in which Title IX has been interpreted through policy guidances, actually requires parity in many situations in the resources and opportunities given to women. And Title IX has also become the source of law for higher education, in particular with regard to how we deal with violence against women and sexual assault on campus. But Title IX has an important connection to the ERA because hearings on Title IX and the vision of gender equality promoted by Title IX were of the same cloth as the legislative hearings on the ERA, and a lot of the same witnesses who testified in hearings over Title IX, including Pauli Murray, also testified in favor of the ERA in roughly the same time span. And that brings me to my next point, which is that the vision of the ERA that was advanced in the 1970s was never only about the Supreme Court. One of the big problems was, as Jessica mentioned, the Supreme Court did not recognize sex discrimination as a constitutional violation until 1971 in the case of Reed versus Reed. And that timing is not a coincidence. The Supreme Court decided Reed versus Reed just as the House, by an overwhelming majority, like over 90% of the House voted to adopt the ERA in 1971, and it would go into the Senate. And it's that at that moment that the Supreme Court decides Reed versus Reed, and then throughout the 70s decides more 14th and 5th Amendment cases recognizing sex discrimination as a constitutional problem and as a constitutional violation. And so one of the main reasons, but not the only reason, that people like Patsy Mink wanted an ERA was to get the Supreme Court to strike down sex discrimination in the law. But that was actually only the beginning. Patsy Mink, Shirley Chisholm, Martha Griffiths, a lot of the primary sponsors of the ERA in Congress wanted the ERA not only so that courts could strike down discriminatory laws, but so that lawmakers could strike up good policy with regard to educational opportunity, employment opportunity, childcare, because without childcare, how would women actually take advantage of the opportunities that were being opened up to them? So this was the robust vision. It was not just about courts, it was also about legitimizing congressional action. And very importantly, Section 3 of the ERA, which almost nobody discusses, Section 3 of the ERA just looks like a procedural provision that says there's a 2-year delay between ratification and effective date of the amendment. But if you look at the legislative history, Martha Griffiths was very interested in that delay because she said that's the delay that gives state legislatures and Congress and really every governmental actor the time to think about what are the laws that exist that discriminate against or disadvantage women. And it was not just a matter of the lawmaker should get rid of those laws, the lawmaker should also rewrite the laws to make equality real. And that's a vision that you see, you could trace the through line historically, where Ruth Bader Ginsburg writes about that vision of the ERA in her law review articles in the late 1970s. She says that the ERA is actually going to lead Congress and the state legislatures to systematically and pervasively change the laws that discriminate against women or disadvantage women. And it's only in the event of legislative default that you would expect courts to step in and play an enforcement role. And that quote from, I'm paraphrasing from Ginsburg's article in 1978, but it's very meaningful that Pat Spearman in Nevada quotes that language as she opens the Senate session in Nevada in 2017, March 2017, that leads to Nevada's ratification. It's a vision where it's not just about the courts, it's about lawmakers making equality real and getting the political and legal legitimacy from the ERA to embark on that project. And I think that's also very important in the higher ed context, because you could think of Title IX as being a legislative project closely connected to the ERA historically, but also other things like Title IX, where not just legislation, but Jessica and I are both faculty members and administrators in a public university system. In a public university system, you are the state or the United States, and the ERA definitely applies to public universities. So one obligation, arguably, of any public official, including public universities, under Section 3 of the ERA is to systematically and pervasively review their practices to see if those practices are consistent with the equal citizenship stature of women in the university. Equal citizenship stature was the phrase that Ruth Bader Ginsburg often used to talk about constitutional equality for women. So I just want to stop there about this vision, this robust legislative vision that wasn't just about courts, and how it would have actual practical impacts on the way that public administrators as well as legislators would behave once the ERA was fully ratified, where there would be affirmative steps taken to get rid of the barriers to women's full citizenship.
Thank you, Julie. So now we get to hear from Liz,
Okay.
who we've been anxiously awaiting.
I am very happy to be here. I'm very happy to be here with Jessica and Julie. And as the comment about my teaching women in law since 1974 suggests, I have been thinking about the ERA, as I know probably many others of you have been for a long time. It is, I think, now a very exciting time to be thinking about the ERA and to be thinking about the possibility that this can actually go forward. Julie just mentioned Ruth Ginsburg, whom I knew as a lawyer at the ACLU Women's Rights Project when I worked at the Center for Constitutional Rights in the 1970s. And I think of it actually since Ruth's passing as something, so many people around the country and around the world became such incredible fans of RBG, who, in the last several years that she was alive. And I think of this as the one thing that the social movement, or one of many things, but certainly a very important thing that the many social movements around women's rights that have been percolating over the last several years can really do as a tribute and a living legacy for Ruth Ginsburg's work and everything that she did. But I want to pick up on a number of themes that both Jessica and Julie mentioned, and talk about them in a little bit more detail. The first thing that I would just say is that if we look back at the history, and I think both Jessica and Julie's books have been very important in this, and I would really urge the audience to take a look at them, is that we know that social movements, particularly social movements of women across, not only in this country, but internationally, has been a hugely important development over the last 20, 25 years. And it's incredibly exciting to see how in the last, and I would say maybe 5 years or so, it certainly goes back longer, but I think 5 years is a big period of time, how with the Women's March, Trump in office, and Me Too, how that has really had an enormously energizing impact in terms of younger women. I mean, I want to say candidly that from, when it didn't get ratified in the early, in 1970s to, very, in the last really 5-10 years, every year I would be teaching about constitutional standards of equal protection and, very important cases that were decided, and then really pose to the students, why don't we need the ERA, and wouldn't it make such a difference, and even give them there's some very, very powerful early writing in the 1970s with some very eminent constitutional scholars about, why we need the ERA. And I want to say candidly, it was very hard to get students even committed, even activists who were going to law school to do women's rights, really excited about the ERA. Now, I think that what has happened over the last 5 years, and that includes many things. I mean, I mentioned Trump's presidency. The Me Too movement has had a huge impact, I think, and has revived a legal movement around sexual harassment that had existed for 20, 25 years before that, but gave it a new energy and gave it a new direction, in a sense that people could really, that women could really make a difference. I think also the congressional elections in 2018, also of seeing many younger activist women getting elected, also has had an impact. I also think state equal rights amendments have had an impact. There have been, when the ERA did not get ratified as a federal matter, many states passed state ERAs, and much of the law that has developed in those as a result of interpretation, judicial interpretation by those state ERAs, has been very important and very useful. I definitely think that, as Jessica mentioned, cases like the Morrison case, the case involving Christy Broncola that she mentioned, and a much more widespread and pervasive understanding of gender violence has had an impact. But I think that it is right to say that, and I, in a way, wish this panel were way before 2 weeks before the election. But I think honestly that as a national matter, I mean, I certainly recognize the incredible intensity of COVID and the problems of racism that we have been grappling with. I mean, there have been obviously many, many things going on in the world, but I would have liked to have seen much greater attention to the Equal Rights Amendment and to women's rights more generally I mean, I think honestly, we now are seeing this in what the polling tells us about, who appears to be coming out and really voting in very strong response. Suburban women, women of color. And, there seems one of the things that is so striking is this enormous gender gap that we appear to see in polls in terms of dealing with Trump. Now, whether or not the enormous misogyny and outrage, Gretchen Whitmer and all of those matters have something that contributes to a greater sense of identity as women and a greater sense of even the possibility of a broader understanding of equal rights now, I don't know. But because I do believe that social movements are the source of change, both not only in the law for judges, but also for legislatures, I think those are very important. Julie mentioned the status of the Supreme Court, and I can't emphasize enough that many of what are certainly some very positive changes that we've seen in much judicial decision making, not only by the Supreme Court, but by other justices, is going to likely, of course, we don't know what's going to happen, but are likely going to be very threatened at this point if things go ahead in the way that they appear to with the new justice, the new potential justice. I can't even really say the new justice yet. But it is true that legislatures are very important, and it is much more important now. The story that Jessica and Julie were telling of the new energizing around the ERA is a story of legislatures. It's a story of legislatures and women who, had never imagined that they could sit in a legislature and that they could make a difference. That's the story of this new energizing. So, just as we've said during lots of difficult times before, we often have to rely on legislatures much more than we can really rely on courts. And that may be something that we're going to see. There's no question, I think, that the potential for a much broader understanding of change in women's rights issues is that what Jessica and Julie just said about the range of different issues, equal pay and Title IX and parental rights and all of those things, that there is a much greater potential to view those in a larger context than rather in sort of as individual pieces than what we've seen before. The ERA absolutely provides a framework for doing that. But it is also true. We won't know yet. There are the issues that were just discussed about, all of the details about ratification and whether or not the suit against the archivist will work out, et cetera, et cetera. We can't know yet what that will mean, but we can hope that there is an outburst of energy and of organizing and a sense of, possibility and freedom in what we, hope will see happen in the next couple of weeks that will really support it. One other point I want to just make is the interest that this very interesting issue about the meaning of what we now mean by the term sex. And the Bostock case from the Supreme Court in June is a case that certainly in some Title IX contexts may mean some rethinking of what we take at what we assume as a gender binary concept. And of course, it's ironic, I can remember doing organizing around the first, the Equal Rights Amendment in the 1970s. And two of the very, very major issues that were constantly being brought up to be very negative about the ERA were LGBT issues. What was this going to mean in terms of, were we opening the doors through equal rights to issues that related to lesbians and gays, et cetera? And honestly, at that point, I want to say there was a lot of wanting to put that issue kind of on the back burner at the time around the ERA. And ironically, another issue, hard to remember, but true, was bathrooms. How would we handle the notion of bathrooms? Well, of course, since then, we've all managed fine with all sorts of, airplanes, et cetera, et cetera. But it's so interesting that in the LGBTQ world, and particularly around issues of sex and transgender issues, how that issue of bathroom access comes up again. And I think that says something about fears that people have in ways that I think have to be very much addressed. Now, we do have a more intersectional and broadly inclusive women's movement now, I would say. I mean, we still have ways to go, and it's not as inclusive or as intersectional as it could be. But what I hope is that there are now a much broader range of women from all perspectives, from all areas, who can see the advantage of the ERA. And I also hope that another issue, which was lurking in the background in the 1970s, about elitism, and that the ERA was really something that was thought of by sort of elite white feminists, that we now have a broader movement that cuts across class and race and ethnicity, and recognizes the ways in which the ERA could have a tremendous impact as well on low-wage women and women who are from immigrant backgrounds. So I'd like to see all of these come together. I'd like to do this for Ruth. And I hope that you all who are listening will engage with organizing and getting out the word. Thank you.
Thank you, Liz. So I'd like to tell the attendees that they can now start posting questions in the Q&A section. But before they do, I have a broad-based question to ask you all. and then a more focused one. So broad-based one is, all right, we're all employed at academic institutions, right? I'm at Rutgers, y'all are at various divisions of CUNY. What difference will it make in those institutions if and when the ERA passes? How will the passage of the ERA be felt on the ground for women, all kinds of women in those institutions, if at all?
Well, if I could just speak to that, I think that's where, to the extent that the ERA could actually do anything about unequal pay, I think that public institutions are the ones that will be on the hook for sure. So they could become leaders in having Jessica mentioned that there are all these ways in which the statutory framework that we now have under the Equal Pay Act and to some degree under Title VII is really inadequate to bring out real equal pay. And I think that if we actually take seriously the idea of women's equal citizenship stature, and we think all government actors, including public universities, have an obligation, it might require doing more than what's currently done to ensure equal pay. But I would say beyond that, one of the central arguments of my book is that beyond the specific nitty-gritty things that the ERA is going to do in terms of changing behavior or legally requiring certain changes in the doctrine, I think the bigger picture as to why the ERA is important actually has to do with what Liz was just talking about, just the broader base of women who have been participating in making the ERA happen. And this is women of color, transgender women, intersectional in many respects in the state legislatures who have been making the ERA's meaning, and the women who have been fighting across generations. And so the idea is that finishing the ERA actually validates that project and makes them into constitution makers and founders and framers. Whereas it's really clear that whatever progress we do have today, so much of the progress that we've made in gender equality was because of the movement in the 70s for the ERA. So even if we didn't get the ERA finished, the ERA movement is what led the Supreme Court in 1973 in Frontiero versus Richardson to start scrutinizing sex discrimination more than it had. And so it's just also a question of, I mean, if to the extent that we're saying the glass is half full, the half full is happening because of women advocating for the ERA. And if you don't legitimize the ERA, it's a way of delegitimizing women as constitution makers. And I think that point is actually much more important than what we think it might do, because what it might do really depends on who's in power, who are the judges, who are the administrators, who are electeds, and depending on who they are, ERA could mean one thing or another. But fundamentally, I think finishing the project is really about validating women as equal citizens and equal constitution makers.
You know, if I could just add something there, I just want to pick up on this notion of citizenship. And I'm sorry if I'm focusing too much on these 2 weeks that we're in, or the pre-voting, but it's obviously, I'm sure it's on all of our minds, not just mine. But one of the things that has been so fascinating to me has been the unbelievable, now that we have this early voting, which we've not had before to any degree, the numbers of people who are coming out of the woodwork and wanting to vote and standing on lines for 5-6 hours. And this notion of citizenship, of women as equal citizens. I mean, voting is one of the most important aspects of citizenship. And it is very important to see how perhaps some of these things that we've been talking about as percolating over the last years have led to a tremendous rise in women voting. And, we hope that that will lead to other dimensions of engaged activity and organizing around what citizenship can be besides voting.
Yeah, I would agree with what both Julie and Liz said, for sure. And, I think to your question about these institutions, I've been following a case in Louisiana, which is, I hate to say funny, but there's a general counsel, a woman who was general counsel, and she had to defend the university on an unfair pay claim from someone else. I think it was even in the counsel's office, who said she was getting paid less than her male colleagues. And in the course of all of the discovery, the general counsel found that she herself was getting paid $40,000 less and ended up becoming a plaintiff. So this is live, this is real, and it's affecting many, many people who never get to bring a lawsuit. And it's hard to make progress on this. So that's not something limited to the university setting, but obviously that would be one way that I think there could be some assistance. I also think, and I have a very expansive, non-litigation based maybe view about the law, but I think that my hope would be with an ERA that we would break out or have an opportunity to break out of some of the narrowness that has been imposed on the language of the 14th Amendment. And it obviously does depend on who's sitting on the court and what case comes when. But I just think that, we need to bring big problem with Title IX is private universities. Like, we really need to have everybody fall under the umbrella of protection. And so ways in which we can take a tabula rasa, more or less, of a new amendment and try to really go back to some of the arguments. And I was so struck by some of the dissents in those early 14th Amendment cases that really clearly understood, the way so many of our justices have, that private area discrimination is a much bigger problem in many ways than public sector discrimination. So trying to use some new tool, we don't know exactly how that will work out, but it gives us a new tool that we didn't have before. I think that's exciting for everybody in any institution and everybody outside of institutions. And on the larger picture, I just want to second what everyone is also saying about the growing intersectionality of our movement. I think when we look back at that Women's March, which was so huge, the biggest march in history, I think one of the reasons it was so big and successful was because it was so broad in its concept. And that if you look at the charter of that march, the document that was adopted, it's not a very narrow vision of women's rights. It's everything. It's climate change, it's racism, it's all kinds of issues, all of which have a lot to do with women, but haven't always been at the center of the women's movement agenda. So I think having that expansive view brought many people in, and that's what we need to do as a women's movement, is to continue that kind of big picture of what women's rights means. So those are just some thoughts to build on what was said before.
So let me just check okay, there are no questions from the floor right now. So let me just continue. So on the subject of women's pay equity, right, faculty women's pay equity, I'm at Rutgers University. A group of women have just sued the institution with a pay equity claim, right? Even though we have in our collective bargaining agreement a new process to pursue pay equity, the process is not going smoothly. Princeton just settled, so it adds to the list of cases. Do you have any comments on, again, bringing this closer to home, any comments on the persistence of pay inequities among faculty women or not? The fact that a university's defense is often that, yes, men on the average get paid more, but they're in the hard sciences, or they're in economics, or they're not in history. My degree is in 17th century American history. They're not in English, etc. So any observations on that topic, which is very top of mind for me for obvious reasons right now?
Well, I can't say a lot here, but I can say it is certainly something that I follow very closely, both in university academic, both public and private, and also in the law school world. And obviously, when you're dealing with a specialized, institution like law schools, you really can't say things like, well, you're in the science lab and, she's in something else. I mean, I think honestly, even in undergraduate and graduate education, those notions of hard science and getting, federal grants and all of that have pretty much been demolished as defenses. What you do see in many of these institutions are things that are based on the sort of prior salary rule. This deals mostly with people who are lateral moves, but that if you've been at an institution where your salary was higher, or for example, you had a chair. I mean, these are things we see in normal pay equity situations of, this is why, for example, there have been several states that have banned the notion of being able to ask women what their prior salary was. And that issue, by the way, has not been resolved. I think is coming up again this term in the U.S. Supreme Court in an equal pay situation involving not academia, but high school teachers. But the point is that there are, I don't think that you see so much the different fields, although maybe I'm wrong about that, and maybe you do see that in university settings, but you certainly see many other kinds of defenses about, well, this person made more money when they were brought on as a lateral, or, for example, a common thing that happens is that a faculty member threatens to move to another institution, and then they use as leverage what the salary would be at the other institution, and see whether or not the home institution wants to raise their salary in that way. Now, this is obviously for, elite professors in academic institutions. But these are very big issues in terms of equal pay. And there have been a number of successful suits in the law school settings over the last 5 years or so, where there have been settlements, big settlements.
So if I could speak to that issue, can I just, Karen, are we actually going until 3:30 today?
Yes.
Okay.
Yeah, no, we have plenty of time. Yes, please do speak.
Okay. So I just want to, just building on what Liz said, I think in academia, there are a bunch of issues. And I think you're right, Karen, that sometimes there's a bunch of incomparables. Like, can you really compare in English, what's going on in the English department to the salaries of scientists or even law professors? But I think beyond that, I mean, Liz mentioned some of the lateral issues. I think there's actually stereotyping and just old-fashioned sexism that goes on in a lot of that, because even the idea that the threat of a lateral move, the idea that a man can say, I might put my feelers out and see if there's a job for me somewhere, and that might move a dean to throw a little more money at him. The dynamics work out very differently. For a woman, it's like, unless you've produced that offer, why would the dean offer you more money? I think there are also dynamics where sometimes the person who's in charge does not believe that a woman would move, because a woman would have to move her whole family, whereas a man can move more easily. And so a lot of those stereotyped assumptions about how men and women behave, I think, affect the dynamics by which people negotiate for higher pay. And then there's negotiation. I think I once remember Joan Williams in a panel saying, do women not negotiate? And there are all these studies about women in negotiation. But one explanation is not just that women are shy about negotiating. Women don't negotiate because they know that negotiating is going to be a turnoff when it comes from a woman and will not be received as in the same way. So there are all kinds of dynamics going to stereotyping, but it's not really clear whether having more laws against discrimination are really going to help you get remedies for that. So I think I'm much more in favor of more structural solutions. So, and I'm not sure how it would translate into the university setting, but if you look at Scandinavian countries and France recently, in France, they passed a major equal pay bill in 2018, which requires the largest corporations to actually measure equal pay by indicators that are laid out by the statute. So, you know, how many women actually got a promotion after they came back from maternity leave? If you have a certain number, you get extra points. If you don't have any, you get fewer points. What is the gap overall between men and women? So there are all these different ways of measuring. And if a company falls below a certain score, they get a warning and they have 3 years to correct it based on those various indicators. And they have to post their score on their website. And so you can think about that. I mean, and I'm not saying this is the exact way that you should do it, but I think the general approach of figuring out all the ways that you can measure, taking into account that sometimes it's hard to make apples to apples comparisons between people, but trying to take all that into account and make companies be transparent or make universities be transparent and give them scores, give them an opportunity to correct if they were just not even aware of the inequalities that they were perpetuating. But if they're given an opportunity to correct with awareness and they don't do it, I think that's a good opportunity for the law to intervene. But you need to have lawmakers who are willing to learn from the many other regulatory frameworks that exist outside the United States on equal pay and to design things that are sensitive to the specific dynamics and situations of the institutions that we inhabit. And I think there is some possibility, if you think about the ERA, it says equality of rights under the law shall not be denied or abridged. And if you think that if you have a situation in which you don't have real equality on the ground, at some point, the lack of action, the inaction by governmental actors and public institutions becomes an abridgment of the equality of rights under the law, then I think that could be a very strong argument, not just for getting courts to go after it, but for legislators, for being on the hook, for coming up with creative solutions that we haven't had before.
No, go ahead, Jessica, go ahead.
I was just going to add to that. I mean, I don't think it's really either or. I think the way in which law and social justice interact, you know, is very synergistic. And I think, you know, Europe has actually been able to do a lot of things that I think is very hard for us to think about doing. Lots of concepts that are so basic, like affirmative action, are very difficult here. And I think it's interesting to see the dynamic changing on the non-legal side with companies like Salesforce, where you have the CEO saying, because a number of high-level women in his company wanted him to do an audit on equal pay, and he really believed, if you listen to him, that there was no problem with equal pay in his company, and then was surprised to find that actually there were, you know, millions of dollars of unequal pay going on, and he fixed it. And then that becomes a model. I mean, not as many companies we would like have taken up that model, but I think that there's a kind of way in which you were talking earlier about women threatening to leave versus men threatening to leave. There's just a raw power dynamic that goes on. And the more power women have, the more equality they can also get. And I think women are over time being taken more seriously, which is helped by their legal standing, but also by their, you know, sort of social progress. And I think that in some of the Me Too cases, you know, I was really struck by how ineffectual the courts are compared to some of the activities on the economic side. When some of those big, like Fox News stars were going down, it was not really because women were screaming online. It was because there were advertisers threatening to pull their ads. And I just kept
Mhm.
thinking, like, there's got to be some women in that Mercedes-Benz or whoever is the advertiser going, we're just not going to put up with this anymore, which never would have happened. It's not that this behavior hasn't been happening, and it's not that women haven't been crying about it for a long time. It's that suddenly you have women in a higher level of power in the
Mhm.
workplace, in the corporate workplace in particular, that can do things. And then the law also can become more effective, even if it doesn't change, just by virtue of having more women judges, more, just more of all of that representation and equality. So, um, so I,
Well, I want to, if I could just add one more thing to what Jessica just said, I do think that there is a relationship to law that we should be very concerned with as the ERA moves forward, which is this. So in California, to try to get more women in positions of power, they passed a law in 2018 saying that corporate boards have to have at least one woman, more women if it's a bigger board. And I think just a couple weeks ago, California passed an additional law saying that you had to have at least one person who's diverse, like a member of an underrepresented group, whether racially or LGBT wise. And before the ink was dry on these laws, and certainly the one having to do with women on boards, conservative legal organizations are bringing lawsuits claiming that it's unconstitutional to have a law requiring companies to elect at least one woman to their board,
Mhm.
because that means that's making a sex distinction, or the law is requiring a company to take gender into account. And I'm sure they're going to bring similar lawsuits against this new law that just passed a couple weeks ago. And honestly, the 14th Amendment doctrine around affirmative action gives them something to work with. And I think this is where it is really important, as the ERA is not completed, for people to really say what they think the ERA should do on this issue. Because some people believe the ERA is going to lead to strict scrutiny, but if it leads to strict scrutiny, it's going to be fatal for affirmative action for women, or it's going to make it much harder to justify affirmative action for women in the courts, in the way that the courts currently apply that test. So I think it is very important when we think of practical issues like this, measures to empower women and to increase their representation. How is the ERA positioned in relationship to that? And how is it different from the 14th Amendment? I think that's actually a critical question as we see more and more judges who are sympathetic to the anti-affirmative action view of the 14th Amendment take up judicial positions.
if I could just jump in on that too and say, I think to the extent that we can use anything that's new, which has that advantage of simply being new, to move towards a vision of substantive equality and away from the sort of formal equality that has really resulted in many ways in keeping us in the status quo, and even giving people who are opposing things like affirmative action a tool to work with against it, that would be an advantage. And to just go back to something you had said earlier, Karen, I think, even though maybe some progress has been made in our own legal system, if we can also come back to the area of comparable worth, where I think much more progress has been made in other parts of the world, to understand that is a fundamental equality issue. And if we can try to integrate that more into our law, I think that will be helpful.
Thank you, everyone. So we have about 14 minutes left. I want to pose one more question because our attendees are still enjoying our conversation, but not asking questions. So let's just keep it going. I don't even know if I want to pose this question. Okay, the election. It's top of mind for all of us, right? What happens with 4 more years of the current administration in terms of the prospects for the ERA, and what happens if the administration is taken over by, the presidency is taken over by the other party? And I know there are embedded layers in here, so I'll let you pull out the layers.
Well, I can start. I just can't even imagine the former. I know I'm in deep denial. It's been the most horrible 4 years in terms of treatment of women, and misogyny manifested on a level that was just impossible to believe. I feel very I am hoping that the other party will win. I think there will be, if they do, I think there will be incredible energy and organizing on so many different levels, and that I'm hoping that the ERA would be one. Obviously, if that does not happen, we're gonna have to live with a very constrained judiciary and hope that we can find states that where ERAs can be passed and where legislators like those who have been active recently will continue to work on this. But I'm in that event, if Trump is reelected, it is hard to imagine anything other than just trying to keep our heads above water.
So I would like to say that as far as the ERA is concerned, Article 5 of the US Constitution, which governs the process by which amendments are made, foresees zero role for the President of the United States. So the President's opinion about the deadline has no bearing on whether or not the ERA is law. So I'm focused much more on the Senate. If the Senate flips, and then the Democratic majority is maintained, and not just Democratic, there's been bipartisan support across Congress for the ERA. So, but if there's enough change in composition and a retaining of ERA supporters as a majority in the House, you could very well get congressional action to remove the deadline after the next election, even if Trump is reelected. The problem is that depending on what the composition of the Senate is, Trump might be able to continue his push to remake the federal judiciary, and that'll affect the way that the ERA is interpreted if litigation is the primary path by which it's enforced. But I think if Trump is reelected, but the composition of Congress changes, I think that the fact that the ERA has made this much progress, thanks to Jessica's coalition and other groups, really creates a possibility of remaking the American public debate around amendments. We don't amend our Constitution very much. The last time we had an amendment was 1992. I was not even old enough to vote in 1992. And that amendment is known as the Madison Amendment because James Madison, a founding father, actually wrote it. And then it took 203 years for the thing to get ratified. And that's just, these are all evidence that I think Americans, certainly of my generation and younger, are very out of touch with the possibility of amendment as an avenue to constitutional change. Now, amendment is very hard because Article 5 requires both houses of Congress and 3/4 of the state legislatures. But I do think that people who care about having a different vision of America and a different vision of the Constitution than the one promoted by the current administration should get involved and should try to see the amendment process as something to which they have access. And I think that the way in which the ERA has been remade across generations is a beacon of hope in our thinking about citizens' access to the constitutional amendment process.
Great. Thank you, Julie.
I would just
Jessica?
say, yeah, just a few things first on the ERA and then some other comments. On the ERA, I think, it's true that the president has no formal role, but it's also true that it's the Justice Department that's really opposing the lawsuit very actively that's underway. So I think a change in the administration could immediately affect a change in the positioning of that lawsuit. And that lawsuit, remember, says basically the ERA is already the 28th Amendment. So that's one route. Then the other route, the Senate route that Julie mentioned, I also think, I agree that, who's in the Senate is going to have a huge impact on that angle. And that intertwines with the lawsuit. But I think that I think that there's some hope there. It's interesting on the legal side, that in a way the strict constructionists are the ones that we can look to also to say, is this, if you're really a strict constructionist, then The ERA is already the 28th Amendment. I mean, that's what Article 5 says. There's nothing about a deadline. There's nothing about anything here. So it would be interesting to see how that plays out if that case goes up. And we have this more and more conservative judiciary. But I think that, the ERA, just taking off that hat for a moment, is such a small piece of this. Like Liz, I can't even really imagine that kind of an outcome. And I get calls all the time and emails and WhatsApp from all around the world. People are watching this election with so much more focus and anxiety than, that really matches the same level of focus and anxiety I think that we have, many of us in this country. And it's not just the women's issues. That's a huge part of my issues, of course, but it's also the pandemic, just the fact that tens of thousands of people have died unnecessarily, I think is, national public health emergency. So I just, I guess I can't really go there in my mind to think about a continuation of that kind of lack of leadership, because it's just so devastating to the planet, to the foreign policy that we have, to our domestic policy, and most importantly, to the lives of so many Americans. So I really think that what women said in the 70s, we'll remember in November. We have a lot of things to remember right now. We can start with the small thing of like who voted against the ERA in Congress, or who's refusing to support the removal of the time limit in the Senate. And then there's really right up at the top level of like, who lost people in the last 6 months that might still be alive.
Right. Thank you. We have 6 minutes. If y'all want to do sort of 60 seconds each of last words or not, your choice. I think we've had a really, really interesting conversation here. I've enjoyed both your talks and especially our last 30 minutes of interaction. It's been my honor and privilege to moderate this panel with you. Julie, I have your book on Kindle, but I'll buy a hard copy so I can get a book plate.
Oh no, you're 2 copies. That's I'm happy to send you the book plate to put on your Kindle device.
Okay, I'll slap it on the back of the Kindle. Thanks, that's a plan. All right. Okay, so thank you very much, guys. It's been terrific. Thank you so much. Hope to hook up with you again on some other project. Thanks a lot.
Thank you,
See
Karen.
you all.
Okay,
Nice to
thank
see
you.
all of you.